Uama ke ao kaina I ka pono o Hawaiian Uama ke ao kaina I ka pono o Hawaii.
Aloha ahi ahi kako, and welcome to another edition of Kanaka Express. I'm Kali Gumopak, your host for tonight, and I'm glad that you have invited me into your homes because, again, like all the other episodes that we had, you're going to learn a lot of information, and tonight it's going to be about land because there's a lot of questions as far as land is concerned. What is crown lands? What is government land? What is fee simple? What is a royal patent? And what is coolie on the lands? A lot of terms are being thrown out there all over the place, and people are having trouble knowing what that really means. And tonight we're going to be discussing that, and I'll be bringing in Donovan Preza, who is a professor at Kapiolani Community College, who is an expert in this area. But before I do that, I'd like to welcome my awesome kumu from Kamehameha School's East Hawaii campus, Kelly Akina. Aloha, Kelly.
Hello, Kako. Naho makamaka. Welcome back again to Kanaka Express. Here we go one more time. Just learning more, continuing to get educated. Super exciting about land issues, and terminology is a big piece. And I think it's going to be a good night. And just thinking about the why, like for this episode, why is this important? Yeah, and I think about that all the time. Is why is land important to our people? And I like listening to different sides, but ultimately thinking about if we understand the terminology, then we can actually make better decisions for the future. And sometimes land has different connotations, but just traditionally for our people, just thinking about our relationship to Aina, how we have a familiar relationship to this place. We've been here for many, many generations. And so understanding how the land evolved from pre-contact Hawaii time all the way into the kingdom time. And I always talk about like our ali'i, what's best for the land, best for the people is how they make the decisions. And hopefully we can continue doing that as we learn more about land and land issues and the level of understanding that our kupuna had during the 19th century related to land. And again, like Kali said, all those definitions and understanding those different parts. This is not going to be the end all show. This is like the beginning or the continuation for some about our relationship as Hawaiian nationals to our national lands. And so super excited to learn more again tonight. So aloha mai kako. Welcome.
Yes, and the other thing that's going to be really interesting, is the relationship that people currently have, if they own property. And I get this question a lot from non-Hawaiians, when they ask, well, what's going to happen to me if and when the Hawaiian Kingdom is restored and the government is in place? And so we'll be able to hopefully address that, so that and the other question is, as Kanaka Maoli, they ask a question, okay, so what happens to the land that I'm on as a Kanaka Maoli? And so hopefully we'll be able to answer that question. So I'd like to bring in right now our guest tonight, Donovan Preza, who's a professor at Kapiolani Community College. Aloha, Donovan.
Aloha.
Aloha kako. Thank you for having me. Mahalo for the opportunity.
Well, I think one of the first questions that we always see, and especially for people who have their genealogies in place, so they've been tracking whether or not it was a big issue during the Mehele, the royal patents, and if they get all this information, they're going to be able to get their land back because of the royal patent grant. What can you answer that? What happens, or why is it so necessary for people to do that? If it is.
First question, straight to the royal patents. All right. Let me start with the broad first. The framework. People need to understand that Hawaii has its own unique system of land title. And while it was modeled off of Western systems, British common law system, the American system, it's not an exact duplicate. There are intricacies and things that are unique to Hawaiian land tenure that are very different than America, that are very different than Britain. And I think too often people assume that Hawaiian land tenure is American land tenure, or Hawaiian land tenure, Hawaiian land titles are British land titles. And it's not. It is its own unique system. And you can take a look at that system through the court recordings in the early Hawaiian Kingdom court cases where they're talking about land, and they make such distinctions that, hey, this may be how they do it in Britain, but in Hawaii, it's a little bit different. That's not how we do it here, right? So that's kind of the important thing. Hawaii is its own unique system. It is very similar, but it is not a mirror image. It is not a duplicate. You need to look no further than subject to the rights of native tenants, right? Or some of these other quote unquote peculiarities that people might experience when they buy land in Hawaii, access rights and gathering rights and all of these things that don't exist in the American system or don't exist in the British system. So in order to understand Hawaiian land tenure, you really have to look at and read all of those documents and build your understanding from the Hawaii experience, rather than taking the general theoretical, oh, if it's like America, it must be the same in Hawaii. And that's where a lot of people kind of get into trouble, so to speak. So more specifically to your question about royal patents, there is a lot of confusion today about royal patents. And what's the easy way? The easy way, there are two different types of royal patents. One is a royal patent grant, and the other is a royal patent on land commission award. And both of these are explained in the Civil Code. If you go and look at the Hawaiian Civil Code, it will have this explanation of there being two different types of royal patent. In both cases, a royal patent is evidence of fee simple title, right? So how we understand fee simple today, you own your land. That's all a royal patent is. If you were to actually, so to give context, my master's thesis looked at royal patent grants and the fee simple sale of government lands, right? So royal patent grant is the fee simple sale of government lands. And for my master's thesis, I looked at 3,600 plus royal patents. I bought the microfilm. I converted the microfilm to digital files. I read those digital files, and from those digital files, I created an Excel spreadsheet that was 15 to 20 columns long and 3,600 to 3,800 rows deep. And in there, it had information like awardee, date of purchase, amount of money it was purchased for, so on and so forth. So you could suffice to say that I have literally read all 3,400, 3,600, 3,800 royal patents, which covered up until the overthrow. These patents come in both English and Hawaiian. And if you were to look at this royal patent and look in the English translation for the Hawaiian words, you would see that the term allodial in that Hawaiian royal patent, Olelo Hawaii royal patent, means fee simple, right? So this isn't my definition. If you go and if you literally just read the English and the Hawaiian version, you could see that allotio equals fee simple. And that's one of those other terms. There's a package of terms, freehold, allotio, and all of these terms get misused and misdiagnosed, and that's where we have a lot of confusion today. So two types of royal patent. Royal patent grant is a fee simple sale of government land. Royal patent on land commission award means you now have the fee simple title to your land, which may or may not have been previously fee simple title. I'll stop there, and you can point me in a direction for where you would like clarification or for me to expand on.
So Donovan, when you're talking about the fee simple piece, and I kind of think about it in two different areas. One, we're talking about pre-overthrow land tenure, 19th century, from 1839 or 1848, right, to 1893. How does that impact, or how does the occupation after 1893 impact these royal patents or land title commission awards?
Well, that one gets complicated. Like it kind of depends what question. Is this a totally new question you're asking, Kelly, or is this in the context of royal patents and royal patent grants?
Well, I think that it's kind of in the context where if for my students, we're doing research on looking for royal patents or grants that their family may have gotten that may or may not be in their family today. So how does the occupation, how does it impact the royal grants? Like, are royal grants still recognized, are royal patents still recognized today in our current system under occupation? And if they are, how
well, that's the misunderstanding there. It's the royal patent grant. And let me preface this first before I get blown up on Facebook.
We gotta block you out real quick.
Hawaiians have Hawaiians have rights to land, and their rights to land are preserved in law. They're preserved in the Constitution. They're preserved in that clause subject to the rights of native tenants. So those people who believe that the royal patent grants are some form of trump card or some form of higher order of title, I disagree with them on that point. I do not believe royal patent grants are some higher form of title that is greater than or above other forms of title. And this all gets down to those definitions that I was trying to point to, right? So where I do agree is Hawaiian rights in land in the Hawaiian Kingdom were preserved. And what I would argue is those rights were encroached upon with the overthrow and since the overthrow of 1893. Our reality we see today, for me, is a function of the overthrow of our government, changes in government. Those changes in government led to changes in laws, and those changes in laws are what created the reality of land ownership that we see today. Okay, so I agree. Just for simple language, I'm going to say the royal patent guys, right? Those people who believe royal patents are some trump card, I agree with them that Hawaiians have special rights in land. Where I disagree with them is that the royal patent grant is the avenue to access those rights, right? And this is as simple as go get a royal patent grant in English and Hawaiian and follow the English and the Hawaiian. This was by our ancestors. These templates were created back in the 1840s, not in the 1890s, not in the 1950s. So you literally just have to read the English and the Hawaiian to get the quote unquote definition. And in that definition, you'll see allotio is fee simple. I mean, the template literally says, by this instrument, you now have fee simple title, right? And that fee simple title is not a trump card. So my understanding of the royal patent grant argument today is that if I have a royal patent grant, I have some form of higher ownership to where my ancestors or living descendants today would be able to put some kind of claim on or have some higher form of rights than someone else who is on that property. And that's not my understanding. So it, like, honestly, I do not track royal patent grants, or I wouldn't be doing genealogy research for royal patent grants in an effort to claim something today. I think it's good for genealogy. I think it's good to understand things about our family and our ancestors, but I do not believe royal patent grants give Hawaiians today some kind of trump card where we can go back and quote unquote get our land back. Right?
Well,
And go ahead, Colin.
can you also make the difference between kuleana and royal patent? What's the difference? Because
So
people continually always say, oh, you know, my uncle, they live on kuleana lands and blah, 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 blah. So versus people say, well, I have a royal patent today. What's the difference?
no, and the difference is different parts, different steps in a process, right? So there should be confusion to a degree with kuleana lands, because if you look in Noah Lucas's Dictionary of Hawaiian Legal Land Terms, there's 13 or 14 different definitions for the term kuleana, right? So think about that. 13 or 14 different legal definitions for a single term, right? So that thing means 14 different things in 14 different contexts. If it didn't, we would have one definition or two definitions. We wouldn't have 14, right? So we have, it means different things in different contexts. When most people are talking about kuleana lands, you know, quote unquote kuleana lands, I would assume they're talking about kuleana lands from the 1850 Kuleana Act, right? Where Hawaiians got 28,000 acres, 667 acres of land via quote unquote kuleana lands from the 1850 Kuleana Act. I'm not here trying to say that that is the only definition of kuleana lands, but I think we should understand the nuance, because the dictionary says there's 14 different definitions and how it's used. So I'm not trying to push a singular definition, but if we're having a common conversation about kuleana lands, I would assume that someone is talking about, my ancestor got land from the Kuleana Act, which applies to that 28,000 acre total. The irony is my master's thesis research looked at the sale of royal patent grants, which is the fee simple sale of government lands. That is not included in the 28,000 acre kuleana statistic, right? That's a whole different category, so to speak. The metaphor I like to use is like bedrooms in a house, right? If you have a 4-bedroom house, then kuleana lands are one of those bedrooms. They're one of the mechanisms, one of the rooms. They're one of the ways in which Hawaiians got land. Ironically, Hawaiians got more land from other rooms in the house than they did kuleana lands. For example, royal patent grants, right? So a royal patent grant is the fee simple sale of government land. And this is where it kind of gets confusing, or not confusing, but you have to be precise with your understanding and your definition. In Section 4 of the Kuleana Act, Section 4 states that those people, those natives without land, may apply to the government and purchase land directly from the government. Those lands that were purchased were not part of the 28,000 Kuleana land statistic. They're part of the 167,000 acres that Hawaiians bought between 1840 and 1893 before the overthrow. right? So Hawaiians bought 167,000 acres of government land. And it's important to keep in mind that over 50% of Hawaii was government land. So you had a 1 in 2 chance that the land you were living on at that time belonged to the government. A very, very, very good example of this is Puna, Hawaii, right? So Puna, Hawaii, if you go back to the land documents, the land records will tell you that the majority of Puna is government land. If you look at Puna, Hawaii, how many kuleana lands were awarded in Puna? 32 acres, 32.
Oh,
32 acres in Puna are quote unquote kuleana lands from the 1850 Kuleana Act. So if you have land from an ancestor in Puna, it's probably not quote unquote kuleana lands from the 1850 Kuleana Act. It's probably royal patent grants or fee simple sale of government lands from the purchase. And that's because majority of Puna was government land, so people purchased directly from the government and bought land that way. So hopefully that kind of clarifies kuleanas versus royal patents.
yeah, that helps quite a bit.
If your ancestors have land today from the Mahele era, it's probably from government grants, royal patent grants, and not kuleanas, because you only have a 28,000 divided by 4 million acres, which is less than 1%. It's like a tenth of 1%. You have a tenth of 1% chance of having kuleana lands in Hawaii. You have a much greater chance of having other kinds of purchase lands from something else from the Mahele era.
So, do you think is it important for people to understand where their lands come from in that factor today, or is it more just to understanding their own family history, those types of things? Because like where do people actually look and start to find out those types of things? Like how you're mentioning, you can see the old land grants and stuff like that.
Yeah, I think it's very important that we understand land today. I think, and not just, like back in the day, there were kahuna whose job it was to know all of the lands, right? It was they had to know it was someone's job to have an overview of all of the lands, right? If you're a normal kanaka, a regular maka'ainana, it's not your job to know how many ahupua'a there are on Hawaii Island, how many ahupua'a there are throughout the Pai'aina, right? So I do think it's very important that knowledge doesn't get lost. And let me explain why. Both for cultural reasons, but also like if we're talking land and land title, place names, very important, right? So when Hawaii transitions to private property in 1840, beginning with the 1839 Declaration of Rights and the 1840 Constitution, unlike other places in the world that were mapped and then divided, Hawaii was not mapped. Right? They didn't have a overarching mapping project that inventoried all of the lands, right? This is why today you cannot go to a map. There is no map I can show you that has all of the 1848 Mahele Awards. Instead, what we have is the Mahele book, and we have land documents, right? And in that Mahele book, you have a listing of place names. Right, just as you would chant all of those place names, just as you would oli all of those place names, just as you would use other mnemonic devices to remember the quote unquote inventory, Hawaii was inventoried by place name, and all of that is captured in the Mahele Book of 1848. All right, so let me be clear. I'm not saying they didn't use maps, right? There were maps and surveys were drawn and kuleanas were mapped. What they didn't have was a mapping project, right? So what you effectively had was a map that said your property was 100 feet by 100 feet and go this distance at this degree and go this distance at that degree until you get back to the point of origin. What you didn't have is where is that corner located in a larger reference system. That reference system wasn't created until the 1870 Hawaii Government Survey, and that's when triangulation was created. Triangulation is the same markers that the surveyors of today go back to reference and find. If you buy a house today, they're tying back to a survey point that goes back to the Hawaii Government Survey. The State of Hawaii Surveyor's Office today is the same entity as the Hawaii Government Survey back from the Hawaiian Kingdom. And they're the ones who created this system of triangulation, but that wasn't until the 1890s or 1900s, right? So what we have is a book with a list of place names. What we don't have is a map that has every single land title articulated on it, right? Those maps were started by the Hawaii Government Survey. If you go back and look what the purpose of the Hawaii Government Survey was, it was to create those maps. It was to map all the original land title, because the government was selling 50 acres here, 50 acres there, 50 acres, 50 acres, 20 acres, 5 acres, 10 acres. And all of the maps were made for each individual parcel, but there was no large map which told you where each parcel was in relationship to other parcels until the Hawaii Government Survey, right? So if you think about this, if you want to inventory something, right? If you want to balance your checkbook, you need to know a couple of pieces of information. The most common pieces of information that people mention are the debits and credits. You got to know how much money's coming in. You got to know how much money's coming out, right? All of us today, we just look at the app on our phone and we see, oh, $10,000. Oh, right on, I have money, right? But none of us know if we're supposed to have $12,000 or if we're supposed to have $100,000. Right? Because we don't balance our checkbooks like my mother used to balance her checkbook in the supermarket when she wrote a check. We don't do that anymore. We don't reconcile those debits and credits, right? So today we're used to this system where we know what we have, not what we're supposed to have. If you want to know what you're supposed to have in your inventory, you also need one more piece of information. What piece? Let me put the two of you guys on the spot since you guys started me off with the hard royal patent grant question. What piece of information do we need to do a proper accounting of our checkbook? Debits, credits, and
Balance.
To start.
The opening balance. Right?
Yeah, balance.
If you don't know what you started with, if you don't know what your initial deposit was, what if my initial deposit was $1 million? But I only have $10,000 left, right?
You got to change banks.
or wives, right?
That too. Maybe change both.
Right. So
yeah,
you need the opening balance. What Hawaii land title does not have is the opening balance, right? This is why you can't get. I don't want to say can't. This is why it's difficult to get a ceded lands inventory. This is why it's difficult for
in the Kingdom era, though, they must have had balance when they started, right? No.
Nope, because we started off with place names, right? And many of these place names were given without survey. So if I give you, if you got Waiakea, Kale, how many acres did you get?
Oh, that's big, depending on where.
But do you know the exact acreage?
No, haven't any idea.
Right? Times 2,000 ahupua or 1,000 ahupua, right? So yes, you got Waiakea, but quote unquote, how big is Waiakea, right? So what we don't have is that initial inventory. We have a list of place names, But what we don't have is that opening balance, right?
Okay.
So go ahead.
Now, would it be possible if we went back and after the overthrow, a lot of the place names, the ahupua'as and so forth, were replaced even today. I'll give a good example, like Leilani Estates, and the name Ke'ahi Alaka was taken away. So what happened? What would happen if we were able to reestablish all the ahupua'a and the ili and the different places? Would that help?
Oh, that would help tremendously. It would make it much more difficult for people who wanted us to forget, quote unquote, wanted us to forget our lands. It would make it much more difficult for them, right? Because think about this: if you erase a place name, there goes 20,000 acres,
Wow.
5,000 acres, right?
Wow.
All you got to do is erase a place name. And that erasure of the place name can take many forms. It can take us forgetting. It can be a deliberate act to erase a place name off of a map so that the descendants today who don't know that their ancestor once owned it in 1950 or 1920 or whatever the case may be, just erase it off the map. And then it's gone. Nobody's going to find it. Right? This is where place names and knowing the story and reconnecting to the land in that way, super, super, super important. Right?
Well, so let's say we go back to the place names and so forth, but because of all of the development that has taken place on the land itself, would that have wiped out all of the, I guess, the checkpoints in the description? Would that render a huge problem if we went back to place names and then there's existing developments that wiped out the coconut tree that you were supposed to start out at and the rock that you're supposed to go up to and so forth?
Well, that one's a slightly different. It's related to the question we're talking about, but slightly different, right?
Yeah.
Now we're getting into boundaries and boundary markers. Right? But like in order for us to get to boundaries and boundary markers, we got to know the name of the land that we're trying to describe, give the legal description for. Right? So if Waiakea is not even in your consciousness, then you're not looking for the coconut tree that is one of the boundaries or the ahu or whatever. Right? So what you're saying, yes, is important. But I'm one level higher where it's what is the name of that land that we're trying to describe with those boundaries. And how this happens is, right, like, so think if two ahupua'a are adjacent to each other, or three. So you have three ahupua'a, yours is the one in the middle, or your ancestors was the one in the middle. This belonged to somebody else, this belonged to somebody else. You forgot the name of this one. Now his boundary is that boundary and that boundary, and your name in the middle, you forgot. Now he just got 20,000 acres because you forgot. Right? So like, and what I'm trying to impress upon the audience is these names are important because that is the initial inventory. The initial inventory is a list of place names in a book, in a land document. Have those land documents all been compiled in their totality? Probably not. Right? You would need someone who wants to know the answer to that question to ask that question to begin to figure it out. Right? So yeah.
So in the Mahele book, you mean like so it has the list, and somebody would have to want to look up each patent or each thing and actually coordinate that with the list, and that would be the first step to identify the beginning or the start point of the land divisions. Is that what you mean? Is that
If you were truly trying to do this, then you would need to get a list of all the names of the ahupua'a and other original land title from the original books, and then create a master list of names. Yes,
wow?
right. Because
That's
if I just go to a map, right? If I just go to a map, then what is on that map is what is on that map. I have the existing inventory. I don't know what should be on the map. I know what is on the map. What if that map has 70% of the names? Where'd the other 30% of the land go?
yeah. We can see it already with the I know in class we have Columbus Schools has a map of each island, and there's other versions, and you'll see like there's differences in names, differences in places. For instance, like Paradise Park, one of the names they have on there is Waikahikahi, but then there's Waikahikahi Nui, and there's Waikahikahi Iki, and then there's Makuu. So there's multiple names, but some maps don't have it. It just says Waikahikahi. So like the two get blended together and gets wiped out. So we can see
And
that already.
imagine if your families owned those two other names that got wiped out.
Right.
So what happens? If somebody comes up and says, "Well, the property I have is located on TMK such and such." How does TMKs play into this? Into what you're talking about?
TMKs are tax map keys.
Right.
Keys. So in Hawaii, we do not have a land identification system, right? A land identification system would give a unique identifier for each and every piece of land. An example of this are the city and county roads in a particular area where their TMK is just 0000. And that road has the same 000 number as a road up Mauka or 5 miles away. Or suffice to say, we don't have a land identification system. What we use instead is the tax map keys to be our pseudo stand-in for an identification system. And as an identification system, it suffices, so to speak. But you have to understand those maps were created for taxation purposes, not for land title purposes, right? So those are maps for taxation that we use for land identification. That's not, or in 1900, I think it was in 1903, the tax map key system came into existence, right? And when I talked, so my background is geography, right? So cartography, map making, that's all part of things I was interested in studying. So in my younger days, I went and talked to the tax map guy, and he, part of the history that he revealed to me was when they were first looking at creating the system in the early 1900s, they were actually going to like just use the existing land titles and the ahupua'a system and kind of use that system, so to speak. But then they went another route where they still used the ahupua'a system, but not in as direct a way as the other original manifestation was going to be. So the tax map keys are it's a system for taxation that we use for land title. It's not, its purpose wasn't to map land title. It does an okay job. It does a good job, but it's also confusing because they've changed parcel numbers. They changed TMK numbers. So the same piece of parcel could have 3 or 4 different numbers, hypothetically, 3 different. It's like your car having 4 different license plates and it's the same car, right? Like it could have 4 different TMKs. So when you're trying to track it historically, you sometimes have to be aware of this and track those quote unquote name changes, right? It's like, imagine if you had a name when you were 0 to 10 and a different name when you were 10 to 20 and a different name when you were 30 to 40, right? And so on. That's the potential that exists. In a land identification system, we would have probably only one name for a parcel, and and the genealogy, so to speak, would be much clearer to track. That system exists in land court, where they go back to map 0 or map 1, and you have this genealogy of those changes. But in the regular system of recordation at the Bureau of Conveyance, you don't have that. So land title searches are much more difficult for that reason, that you have to understand the name, tax ID number of the land could have shifted and changed through time.
Okay, let me ask you this question though, in regards to define what it means by crown lands, government lands, and fee simple, and what role does it play for people today, if any?
So let me pull one of those terms out. Fee simple is, in Western property law, there are 3 estates, and this is going to get kind of legalese, but there's 3 different estates, 3 different ways you can interact with land. Fee simple is one of those ways. Leasing is another one of those ways, and a life estate is one of those ways. So in Western property law, if you hold land, it's in one of those 3 ways, right? So fee simple is just one of those, and it's often referred to as the highest form of ownership, right? So fee simple, if I go even a step higher, fee simple is referring to this system where you own your land separate from any other individual. And this is in distinction to the feudal system. So if we're talking about Britain, there's a period where Britain was the feudal system, and then after the feudal system, it's freehold or fee simple, right? And that's, in the feudal system, you got land from a lord. Very similar to Hawaii conceptually, in terms of Hawaiians, maka'ainana, got land from a konehiki, land in exchange for service. That's the basic idea of feudalism. And that's where Hawaii was very similar to Britain, and that's why they borrowed from Britain, because Britain had this system, land in exchange for service. Hawaii had this system, land in exchange for service. There were nuances in Hawaii that were different than England, but that general idea of land in exchange for service existed in both places. And that's why Hawaii borrowed from the British common law system. And so that land in exchange for service, that's the freehold, that's the, you get land from another person, and that person could take it away from you at any point in time. Fee simple, that relationship is over. Now you own your land free from that relationship. The Lord doesn't hold that land above you. Someone else does. Within this, you still have the rights of eminent domain. You still have the rights of the government to tax. You still have all of these other rights that government holds. And this goes back to kind of the royal patent grant argument, where people misconstrue or take definitions of freehold and these other things literally, where there's no lord above you, as if you hold this like in your individual capacity and like with only God above you. No other human can tell you what to do on your land. But if you take a look at that, the government can still exercise eminent domain. The government can still tax you. If you live in a homeowners association, you still gotta abide to the homeowners laws, association's laws. You can't do this or you can't do that. You still gotta pay property tax, right? All of these things. So you don't own it in this absolute above everything else and everybody way. You own it in distinction from this period where we used to hold land in service, land in exchange for service. That system is gone. Now you hold land in your individual capacity, where no human being can arbitrarily take it away from you. And that's where you get into the freehold system. You hold this land free of that relationship, right? So that's the fee simple, which is just one of these 3 estates, one of these 3 ways of holding land, right? Freehold in that, so in Western property law, it's the best way to conceptualize it is you have to understand that there's certain rights you can hold in land, and you can have a certain amount of those rights. If you have 100% of those rights and you hold the entire, this is the bundle of sticks metaphor, right? Where each different stick represents a different right. So if you're renting, you have the right to use the land. You have the right to possess the land. Your landowner holds the right to alienate the land. He can sell the house that you're living in to another individual. That's his right to alienate, right? So you hold different property holders hold different sticks. And depending which stick you have and how much of each stick, that's where you get different terms like fee simple absolute. I have the most sticks and 100% of each of those, right? Because you could have a stick that you only have 50% of or 20% of, metaphorically speaking, right? And that's where you get different terms like fee simple absolute versus fee simple defeasible. Fee simple absolute, no one can take it away. Fee simple defeasible, if a certain condition is met, and this is those examples, you can hold this land as long as you never sell alcohol or liquor on this property. Once you sell alcohol or you can use this land, you own this land as long as it's used for a church. Once its purpose changes from a church to something else, then it reverts back to the landowner. Right? You own it, just that you don't have it in fee simple absolute. You have it in fee simple defeasible. So one of your sticks, you don't have 100% capacity. You have 50 or 20 or 10 or whatever the metaphorical number is. Right? So that's fee simple, which ties back to royal patent grants and freehold and all of those definitions that get confused and need to be understood.
Okay, so what is crown and government lands?
Government lands are those lands that belong to in the Hawaii context, those are those lands that belong to the general population and the proceeds from which would benefit the general population. So that would be the White House. If we're talking about America, that would be the White House, that would be the national parks, that would be other lands owned by the federal government for the benefit of all of the population. The crown lands in Hawaii are a unique and special species of title. The crown lands are lands that belong to Kauikeoli Kamehameha III, and they were his private individual lands. Okay, so let me get the first part of this explained. Think Donald Trump Plaza, right? Trump Plaza belongs to Donald Trump, the person, not Donald Trump, or not the president of the United States. It belongs to the person, not the person not the office, right? So the crown lands originally belonged to Kamehameha III as his private property. That means all of the rent, monies, proceeds for a sale of that land, revenue from that land went to Kamehameha III himself, not to the king Kamehameha III. Went to Kauikeoli, not Kamehameha III. Okay? So that's his individual private property. The confusing thing about this is that those lands he did not have originally, he did not, the one stick for alienability, the ability to sell or discharge those lands was later, the inheritance stick was limited. So in 1864, there's a court case, and this court case is Queen Emma versus Lot Kapuaiwa. right? Kamehameha the Fourth dies. He dies without a will. When he dies without a will, we now have a question: what happens to these lands? Where do these lands go? Do they go to Queen Emma, or do they go to Lat Kapuaiva as Kamehameha V? What the judge in that court case decided, which I think was 100% accurate with what the purpose and intent Kauikeoli had, was those lands were inherited by the office of the king. Okay, so that would be like Donald Trump limiting his inheritance not to anyone. So he didn't have 100%. He limited inheritance to a specific entity. And that idea in Western property law is called fee tail. Right? A fee tail means there's a restriction on inheritance. Right? So this is a concept that doesn't exist in American property law. And it exists in concept, but it doesn't exist in application. It's been outlawed in most states in America. So if you can imagine, we have 1,000 American trained lawyers looking at Hawaiian history, and here is this concept that doesn't exist in what they were trained in. Do you think those American lawyers are going to see it as such? Probably not.
Probably
Because
not.
they're not trained. If you showed this to a British lawyer, they would say, oh, that's a fee tail. There's a limitation on inheritance. So the crown lands belong to Kauikeoli, the individual, not representative of government, right? This was Trump Plaza, but Trump Plaza was inherited by the next president, right? So if Trump Plaza were the same as Crown Lands, then Trump Plaza would be inherited by the next president of the United States. And that's the Crown Lands. So that's how it goes from Kamehameha IV to Kamehameha V. And then this is how it goes from Kamehameha V to Lunalilo. Then this is how it jumps out of the Kamehameha line into the Kalakaua line. And it goes from Lunalilo to Kalakaua because Kalakaua is the next person in office, right? And so all of that was talked about in that 1864 court case. So that was describing the inheritance, right? That court case talked about who inherited the crown lands, right? So crown lands, private property of Kamehameha III, inherited by
Kapuaiva.
the next mo'i.
Yeah. Oh,
So since
In
there's no mo'i now, who
1865
controls those lands?
We'll get there. Very
Okay.
very good foreshadowing. In 1865, we have another nuance where the alienability stick is affected by Lat Kapuaiva. He goes to the legislature and says, hey, we'd like to make these lands inalienable. Inalienable means not available for sale, right? They're still fee simple, or not fee simple. They're still fee, but it's a fee tail, not fee simple. Fee simple means it can be inherited by anyone. Fee tail means it's inherited by a specific entity, right? So this is where you got to track, like, and this is getting a little too legal probably for most people, but fee measures something, simple measures something, absolute measures something, right? You can have a fee simple absolute, or you can have a fee simple defeasible. You can have a fee simple, or you can have a fee tail. Those four terms are measuring two different sticks and the quantity of those two different sticks, right? So this is where you really have to understand the nuances of Western property law. And it's not just semantics, right? In language, there is life. In language, there is death. If you don't know the meaning of a particular word, something's going to die, right? And that's our understanding, and that's our ike, and that's our all of that. So crown lands, fee tail, inherited by the crown, by the next king or queen, also with a limitation on the ability to sell. And that was created in 1865. Let me give you a quick example. Just this last year, like I think right before COVID, New Zealand passed a law where aliens, non-citizens, non-New Zealand citizens could no longer purchase New Zealand land. That's still fee, right? That's still, but you have a limitation on alienability. Now, non-citizens cannot buy land. That didn't change it from fee simple, or that didn't make all of the land government land. That just changed the nature of this one stick with that property, right? So you have two different sticks affected. You have the alienability stick affected in 1865. You have the inheritance stick affected. I don't want to say affected. I'll say adjudicated, ruled upon, right? This was a Hawaiian Kingdom Supreme Court case, right? So this is interpretive law. This was interpreted and decided for us in 1864, right? This isn't my opinion. This is what is stated by the Hawaiian Kingdom Supreme Court in 1864, where they said these lands are the private property of the king, inheritable by the office of the king. Questions before you get to your big question?
Okay, and you still haven't addressed. Go ahead, Kelly. I know you wanted to ask a question.
Oh no, I had the big question.
Yeah, go ahead, Kelly. Say your big question again.
Geez, I forget everything. I'm lost. But I think it was. I was just wondering, like how does that like who controls or the crown lands today? Because it's kind of been
there's no more.
People use it. Yeah, people use it interchangeably. Oh, the crown lands or ceded lands or government lands. But technically, if there's no monarch, then who does that fee-tail lay with or stay with?
That is a very good question, and maybe one of your 12th grade students will do a PhD that answers that question. It's one of, nobody's asked that question because nobody's understood what the crown lands were, right? But the crown lands are more complicated because, so the misnomer of the mahele is that Sugar was buying because of the mahele in 1848, or Sugar was buying land from 1848 before the overthrow. Sugar does not start to buy all of their lands until post-overthrow, right? The people who are buying lands during the mahele era, 1840, 50, 60, 70, and 80, are the ranches, right? 167,000 acres, Kahuku Ranch, South Point, Ka'u. 28,000 acres, Royal Patent grants to Samuel Parker in Parker Ranch, Waimea, right? Ni'ihau, 64,000 acres, Royal Patent grants for the purpose of ranching, right? So the early large purchase, the early landowners in Hawaii were the ranches. Sugar this goes back to the crown lands. In 1865, the crown lands are made inalienable, not available for sale. That's when the Commissioner of Crown Land Leases is created. Between 1865 and 1893, nearly in its entirety, over 900,000 acres of crown lands are leased to Sugar. Sugar is the majority lessee for this 915,000 acres of land. Okay, so they're leasers, right? They don't own it in fee simple. They're leasing. So they get 20, 30-year leases. These leases start to prove valuable. And come 1890, 1880, 1910, their leases are going to be up. And they want to buy these lands. Well, they can't, because there's a statute that says 1865, crown lands are inalienable. So this is where Sugar, the crown lands are basically the prize that everybody wants. You could almost, I don't think it's too far-fetched to say that the crown lands are the reason why Hawaii was overthrown. Sugar wanted the crown lands so that they could purchase them. The U.S. military wanted crown lands for military bases. if you look at the majority of military bases, they're on crown lands. The reason they're on crown lands is because most of the good government land had been sold. I'll give Ui a quick shout out. Aloha Ui. Sorry, just texted me. Crown lands had been. Oh, you threw me off now, Ui. Crown lands. 1865, crown lands are leased to sugar. The U.S. government wants the crown lands for military bases. Majority of our crown lands today are military bases. Kahawiki, Fort Shafter, crown lands. What is Waianae-Uka? Schofield Barracks, Waianae-Uka, Wahiawa, crown lands. Bellows Air Force Base, Waimanalo, crown lands. You name your military base, it's probably on crown lands. And that's because most of the good government land had been sold. So the only available land, like virgin Ahupua'a, without you having to buy 20 farmers out, were the crown lands. So Sugar wants the crown lands, military wants the crown lands, Dole wants the crown lands for homesteads. So these three entities basically overthrow the government. In 1894, in the 1894 Constitution, they create a clause, Article 95, they confiscate the crown lands by basically just saying, well, hey, Trump Plaza? Yeah, that's crown lands because, President Trump, that's not your private property anymore. You were the president, so now your lands are government lands. And that's basically what Article 95 does and says. And in that same article, they say, and the crown lands are now alienable. They can be sold, right? The problem with this is they basically defrauded Liliuokalani from these lands, right? They basically just said, well, these are now ours. Let me just state it simply. They stole them, right? Although you cannot legally steal land because land is immovable property, they stole the land through Article 95 of the 1894 Constitution and through the 1895 Land Act, right? This is where 25% of Hawaii gets taken. And so the lands that were once leased by Sugar, after the overthrow, when their leases are up, they then purchase. So that's where Big Five gets all of its land from the Crown, from the overthrow, from the 1894 Article 95 of the Constitution, and from the 1895 Land Act. Right? So,
and just to be clear, that the 1894, 1895, this was during the illegal government that was in control of the Republic of Hawaii, correct?
Yeah, that's essentially why they overthrew the government, so they could get these lands for themselves. And so that fact has nothing to do with sovereignty, right? This isn't 1893 illegal overthrow. I mean, it kind of is because it comes from the overthrow, but the crown lands, there's a problem with the crown lands, even just in terms of clear land title outside. How did the state of Hawaii get title from the Republic? And how did the Republic get land title from Liliuokalani? That land title report would have to go through the 1894 Constitution and Article 95. Well, that Article 95 is evidence of the theft of stolen property, the theft of property. There is no eminent domain. They didn't take that land, give Liliu compensation, so they can't even claim eminent domain, right? So, like, if they violated the most sacred American law of private property, right? They took private property without compensation from an individual, right?
Okay,
if this happened today.
So how would we go about recovering that crown lands that was taken away. And what would happen to the people that currently live on Crown lands?
Sorry, repeat your question, Kale. Our audio clip.
How would we, whether it's the Council of Regency or an individual, recover Crown lands, and if there's people that are already on the Crown lands, living there, or big development or whatever, what would happen to them?
Well, 25% of Hawaii has bad title, without any arguments of sovereignty, no treaty, no annexation, occupation, no sovereignty arguments, just straight up land title. 25% of Hawaii, Crown lands, but bad title. The interesting question: who gets? I'm going to speak very specific at this time. I'm not saying Hawaiians don't have claim to Crown lands, because there are other avenues where people could put a claim in for Crown lands, but we haven't discussed that, and we're not talking about that specific nuance right now. If we're just talking about land title and what I just expressed, that's the private property of some entity. Like if you owned, Kale, if you own 25% of Hawaii, and why would I have a claim to your land, right? But somehow we today feel as if we have a claim. Like, I don't think I have a claim through this specific narrow conversation to Kaui Keoli's private property that is inherited by the government, by the queen, right? Or by the next monarch. Right. So then now we get the sovereignty issue brought in, because, well, there is no monarch. So what do you do absent a government and absent a representative of government? And that there is a very complicated question that I think we've been looking at Crown lands because it's low-hanging fruit. But if you understand the nuance of Crown lands, I don't know that we have that belongs to the next monarch, not to me or my son or my cousins. Or
so with that being said, things like state or entities making decisions about what happens on Crown lands is not their actual. They have no right or kuleana to say that. Is that correct? Because what gives them the authority to speak on behalf of Kaui Keoli's lands, and what does or doesn't happen there?
All of this, we could have a very intelligent conversation about this if someone in the state government would give to us land title for the Crown lands. Like if you said, hey, Attorney General, can you please give us the land title? Not a big ask. I got to do it when I buy a house. I got to get a land title report when I buy a house. We all do. But it comes back to Hawaii is founded on three illegalities: the illegal overthrow, the illegal annexation, and the bayonet constitution. Illegal, illegal, illegal. It is very difficult to get a legal fruit from an illegal act, times 3. Right? So I can guarantee you that the Attorney General or anyone will not willingly give us a title report for the Crown lands. Because if they could, like if I were the Attorney General and I lawfully own the Crown land, I'd give you the title report and tell you to shut up. Move on. Yeah. Enough already.
Let's open escrow. Here we go.
We own it. And here's the title report, right? But if I make this title report public that says 1894, they just took it from the Queen and didn't give Emmett, they confiscated it without compensation. Well, that's, I forget what article in the United States Constitution. If we pretend we're in America for a little bit, that's a violation of the U.S. Constitution. You cannot take land from an individual without compensation. Right? I forget which article, but it's in the Constitution. I looked it up, and so like they're stuck. I would, if I were the Attorney General, I would not know what to tell you if you asked me for a title report, which means we're not going to get one. I don't ever expect to get one from the governor or because I know what it's going to say. And if you admit that, you've just admitted to violating the U.S. Constitution, which they can't do.
Wow,
So
that sounds like a federal court case that's happening right now.
Yeah.
no, but that's the foundation of Hawaii is on these illegalities. So how do you get legal action from illegal stuff? How do you get a legal transfer of sovereignty when there's no treaty? How do you get a legal transfer of land titles to the crown lands when Article 95 of the 1894 Constitution says we took it? They admitted in that article that they took it without compensation. And that's 25% of Hawaii. And that's 25% of Hawaii that all the big five and all those guys own. And it's a big problem, right? And it's one of those problems that's so big, kind of like this federal court case, that you kind of just have to kick down the road and not deal with, right? But like now we know, right? So and again, it's not a sovereignty issue, it's a land title issue, and they don't have clear title to the crown lands.
Okay, and so we're gonna leave it right there because we're gonna
show me the title report and I'll stop saying what I'm saying.
Yeah, show me the treaty. Show me the title.
It would be great to have you back again, Donovan, so that we can continue this conversation, because there's still a lot to talk about, on this. And any final thoughts that you'd like to share with our viewers?
Yeah, I'll leave our viewers with in language there is life, in language there is death, right? And in those definitions, certain things live. In our misconstrued definitions, certain things die. And for me, it's very important for us, right? This is not academics. This isn't, this is in our own culture, we value the importance of the word. And so learning those definitions, learning those ideas, don't trust what I said. Go read the Royal Patent Grant in English and Hawaiian, right? Like it's not my opinion. It's what is in the documents, right? Go read the Kuleana Act. The Kuleana Act is in English and Hawaiian. The Hawaiian says allodial. The English says fee simple, right? Like we have rights in land. We just have to understand what the kumu is, what the source to those rights is, right? And if we understand the truth and the source of that, then we might understand and we have a much better chance of getting those rights back, right? But if we're throwing mud in the water, no one's going to be able to see what's what, right?
Well,
language important, place names important, words important.
And that's why it's very important to have experts like you to help to clarify the muddy water. We've been in the muddy water for too long, and so it's people like you that really helps to clear that water. And so I'd like to again mahalo nui, mahalo piha for joining us tonight, and we need to do this real soon again because we're not power yet. Billy, any final thoughts?
Final thoughts. Wow, there's a lot of. We need some more PhD candidates out there to do more research, and like Donovan said, understanding the importance of terminology and words. But also, I think that you mentioned too the connection of the mo'olelo and understanding our mo'olelo, of our connections to our mo'okoho, not just to our families but to our places. And if we do lose or start to miss out on remembering these mo'olelo, it takes away of our very identity as Kanaka. So I think it's important, and it's really interesting how law, lawfulness, and what happened politically is sometimes contradicting itself. So just understanding when we talk story in these conversations, first setting the tone of our terminology and understanding that we're speaking about, like you said, land titles. There's no sovereignty, there's no anger issues, none of that. So this is straight land titles. So I think leaving it with that is there's a lot more work to do. And if you are looking for a PhD area or an area of research, this would be a great one. Yeah. So calling all Kanaka, if you're ready, stand up. Here we go.
Aye. And my closing thoughts for everyone is, it's time. It's our time, and our time is now. And people need to start to step up, and be counted. You cannot remain in the shadows and hope that somebody else is going to do it and so forth, because there's been too many of us that have been doing this and trying to get things to happen and so forth. But we need more voices. We need more people to be involved. And is there a risk? You bet. You bet there's a risk. But at the same time, this is our country that we're talking about. This is our independence for the Hawaiian Kingdom that we're talking about. And unless we start to step up and be counted, good example is the letter to the IRS. Fill that letter out and send it in. Let the IRS know that the taxes that they're collecting from you is illegal, and that you are either a Hawaiian Kingdom subject or a protected person living in the Hawaiian Kingdom. And also there's that letter to the taxation department for the state of Hawaii. Same thing, send that in. The more voices we have, to raise, like what took place up at Mauna Kea, the more chance we get to finally huli all of these things, all the illegal acts that have taken place. So with that, I'd like to thank Lynn. Awesome job for all your technical direction, and mahalo to Donovan, Preza, again, professor and instructor at Kapi'olani Community College, and for my host, Kelly Akina, for his awesome understanding and views in what's taking place. And also, he comes with, the questions of the students that he's teaching that are being raised. And so mahalo to everyone. And I hope you join us next week, because I hope to get Dr. Keanu Sai and Dexter Kayama back on, because there are more things that have taken place in the federal court case that you need to get updated with. And so stay tuned, look for the flyer to see who we're going to have next. But I hope to get Dr. Sai, and then again, we're going to bring on Donovan Preza again, to continue our discussion on the land in the Hawaiian Kingdom. Until then, mahalo nui for joining us, and ahui ho. Aloha.
Uama ke ao kaina I ka pono o Hawaii. Uama ke ao kaina I ka pono